Hello. Okay, so this week we're going to do, or this review is Women in Politics. This was one of the longer and I think more complicated ones, so I'm going to try and simplify it a little bit in this review and maybe somewhere give out an exam answer or two. So, what we were looking at in this section is sort of the history of women in politics, the politics of history, and the the politics that surrounds women now, women's bodies, women's lives, and the historical sort of inheritance from that. So we're at a situation today where women are the victims of sexual violence more often than not, or more often than men. Women get paid less than men. Politicians can make statements like if it's legitimate rape, then the body has ways to fight that thing off or to shut that whole thing down. We live in a society or a culture where through expression and social norms that a woman maybe asks for sexual violence to be put upon her, that a woman's credibility is what's at stake in a rape trial, not the man's credibility or not physical evidence. These things that exist because of some sort of historical tradition that we have slowly inherited. So we're looking at that inheritance and why those things exist and how come some people get really upset when statements are made that kind of fall in line with that tradition. So with that in mind, I gave a kind of disclaimer at the beginning of the presentation about why we're having a Women's Politics Week, and why not a Man's Politics Week or whatever. And the idea there is that one, everything is Men's Politics Week because there's a sort of white male gaze on the world where men's issues, white male viewpoint is seen as the default. It's the norm. It's the way society kind of organizes itself around providing dominance to white men. Women's issues, or issues that predominantly affect women, are therefore outside of the norm and are therefore special interests, not issues that are are applicable to a broad range of people, in a way that issues that only affect men are applicable to a broad range of people. So that's kind of why we look at it. It's the argument has been made that by making a Women's History Month, and in this class, I think anybody actually said it, but by having a women's political section, or having a Black History Month, or we did a Black Politics section or whatever, isn't that just reinforcing discrimination or segregation or difference between the races and sexes that wouldn't exist if we didn't have things like that? The argument, or the reason why that argument doesn't work, though, is even if we want to live in a colorblind society, and even if we ourselves believe to be acting in a colorblind way, we don't actually live in a colorblind society. So whether or not we, on the individual scale or even on an institutional scale, try to be colorblind, there are these sort of historical fabrics that have infiltrated our political structure and our current political institutions that create this sexist and racist kind of environment. And by having these sections, by having Black History Month, things like that, we're not trying to reinforce a kind of distinction, at least politically, and create a oppressor group. We're trying to sort of draw attention to issues and people that have been historically marginalized, and draw attention to that institutional fabric that we sort of have inherited through history that is inherently sexist and racist. And by drawing attention to that, hopefully we can fight it and move towards that ideal society where we have a gender-blind, color-blind society. Anyway, okay, so we'll go over a few things here. Women in power. I think, you know what, this can be a exam question, a multiple choice exam question. The number of women that have historically, sort of throughout time, have been elected to Congress. So in any 2-year term or any session in Congress, which is 2 years, and a Congress includes both the House and Senate. So in any session of Congress, there's 535 congressional people, whether they be representatives or senators. That's in any session. That's how many exist. In the entire history of America, we have sent 251 plus 10 plus 33, 261, 296, 294. We have sent 294 women to Congress. So in 1 2-year term, there are 535 Congress people. So, and there have been like 118 sessions of Congress. We haven't sent the number of women to Congress as there are Congress people yet in our entire history, if that makes sense. So, multiple choice answer would be there are 535 Congress people, and there are 294 women in total that we have sent to Congress. So we see there a disparity in political power that women have in Congress, and that actually we see that all throughout the political institutions. Women hold a lesser share than we would expect through sort of randomness, lesser share of the political positions and things like that. Within business, women are even more vastly underrepresented. In the Fortune 500 companies, there are 23 CEOs, and of the Fortune 500 to 1,000 companies, there are also 23 women CEOs. Only 8% of the sort of top executive wage earners within companies are women, only 8%. And there currently are 125 Fortune 500 companies that have no women in the board room, in the board of directors or in CEO positions. Another exam question will be to define patriarchy, because patriarchy is fun to define. A lot of people don't quite get it sometimes. So when we talk about sexist society, we're talking about a patriarchal society in a lot of sense. Now, patriarchy means that men hold most access to most important structures of power, whereas women lack access to important structures of power in society. Living in a patriarchal society does not mean that women are completely shut out of the sort of power of having power of the political process, of being involved in politics, of being involved in business. That's what's not, you don't need to have that 100% all or nothing system to have a patriarchal society. If that were the case, there might be 0 patriarchies in history, because at some point in just about all societies there's been at least one woman that's held very that's had significant say. But the idea is that overwhelmingly women are shut out of the halls of power, or don't really have access to it in the same way men do, that men are way disproportionately, have access to that power. Feminism is the belief that women are equal to men, and that women should have equal opportunity to men in society. Now, within that, that's kind of a broad definition, but within that there are lots of different definitions depending on the type of feminism that you ascribe to and the way you see sort of patriarchy working in society and how you specifically want to take down patriarchy. And we did not get into all those different definitions of feminism. So a couple of important historical sort of places of women in legal society and political society. One, for a very long time, until, say, maybe starting in roughly the 15 or 1600s, and then really kind of taking off in the 1800s, we have the separate spheres ideology. But before that, we have this ideology that men and women, or that women lose all legal status once they marry a man. That legally we only sort of thought of women as being married, and if a woman was married, she is dead in the eyes of the law, or she's invisible in the eyes of the law. She has no existence in the eyes of the law. If a woman goes out and earns money, that woman did not actually earn any money. Her husband earned the money, because how can somebody that doesn't exist earn any money? If there are a few exceptions to this, but if a woman commits a crime, it was the man that committed the crime, because how could something that doesn't exist, a woman, commit a crime? That's impossible, right? So it just makes sense that the men would be responsible for crimes committed by women, and that men would earn money that women earn and such. Because of that structure, women, especially when they got married, had no opportunity to sort of participate within themselves in sort of public life. Also, it led to things like reasonable correction, where men could, or husbands at least, could legally beat their wives for not just like breaking the law, but disobeying order in the house, or talking back or something like that. Because if a man will be held responsible for the actions of his wife, he needs to be able to enforce discipline on the wife. So that's where we get this, what I think a number of people have heard of, of how back in the day you could beat your wife. Well, this is where that kind of comes from. Now, we saw it take dominant or big rise in the 1800s, the separate spheres ideology, and that was outlined in Justice Bradley's decision in Bradwell v. Illinois, is this idea that men and women occupy different spheres in life. So women occupy a domestic sphere and men occupy a non-domestic sphere, every other sphere. So women are naturally timid, delicate, they're soft-spoken, they're harmony, they don't like confrontation, they're weak, they're nurturers. What other stereotypes? They can't do math very well, they can't negotiate, they're dumb. All of those ideas of what women were sort of bundled up in this domestic sphere, and why women could not exist outside of the domestic sphere. So women were relegated to doing things like sewing, cleaning, taking care of children, having babies, for obvious reasons. Teaching sort of children, it began, would begin with like sort of manners and such, but that eventually grew into sort of school teaching stuff. So what you would think of in taking care of the house, taking care of the home, outside of the financial part of it, that was women's area. That's what occupied women's time. And that's where women were properly allowed to be. Men were the owners of business, captains of industry, laborers, they were politicians. They were seen as being better suited to those aspects of life, to the public life, to the life where power actually exists. Now, and you know what, this is a exam question, probably short answer. I'm going to put a short answer. Separate spheres, ideology, good and bad, roughly. I'll fix it up. Okay, so the separate spheres ideology helped to enhance and reinforce, I guess, the oppression of women. We had, I guess, moved away from this idea that it was okay to beat your wife, and it was becoming increasingly not socially and politically acceptable that women would sort of disappear completely from legal existence once they married a man. But come on, we're men, so we still can't let women run roughshod over the place, right? I mean, sure, now we can't make it so they don't exist once we force them to marry us, but that doesn't mean we should let them have access to power. Certainly the discussion that's going on through men's minds as they take up and sort of adopt subconsciously this separate spheres ideology. And so what they do is create this idea that women and men hold different places in society, different spheres. Women are domestic sphere, men are every other sphere. And it just happens to be that women's sphere is the one that doesn't engage in public life, that doesn't have power, et cetera, et cetera. Now, theoretically, this got rid of the hierarchy between men and women. It theoretically meant that men were no longer above women, but just that men and women were separate in some way. They held different areas of power, but really men were still above women. So the separate spheres ideology helped keep oppression going, entrenched oppression, and actually we still see a lot of the oppression that the separate spheres ideology implanted in existence today, and we see the effects of separate spheres ideology today. Real quick aside to that, teacher pay. Women were allowed to be teachers because it was seen as an extension of the domestic sphere of, educating and being nurturing to children. But because women were the ones who were predominantly teachers, it was okay not to pay them anything or to pay them very little. And historically, therefore, teacher pay has been very, very small and a lot less compared to people with similar education and experience. And that's because women held those jobs and women didn't need to make money. men did. Now, though, since theoretically a man can be a teacher just like a woman can, and women shouldn't make less than men, like on the face of it, like automatically, but because of that historical place of teacher salaries being very small, today we have teacher salaries being small. That's how separate sphere ideology has still impacted us today, and that's bad. I think a lot of people would think that's bad anyway. And it reinforced oppression by creating those separate spheres. But the good part of separate spheres ideology, the thing that it offered women that the previous sort of direct hierarchy did not offer women, were chances to organize and chances to actually hold some sort of legitimate authority in any sphere of life, even if it is in the home life, in the nurturing part of it. So once you allow women to join the workforce as sewers, making garments, sweaters and stuff, because that's part of their domestic sphere, and women can now do things outside of the home as long as it's within their sphere. Once you allow women to be sewers, to have a life outside of the home, they can then start talking to each other. And once women start talking to each other, just like any other oppressed group, they can start organizing. And once they start organizing, they can start, creating demands, realizing and rebelling against the oppression that has been forced upon them, and we can get actual social and political change, and that's exactly what happened. As women had more and more opportunities open to them in life, that help the women organize and help women open up more opportunities for themselves. Once they got more opportunities, they were able to better organize, and then they were able to fight for a wider range of opportunities. Think of it as like a snowballing effect. Once you allowed women to participate in public life in one area, it sort of expanded because of the struggle of women to make it expand. So that's kind of the good and bad of the separate spheres ideology. Was a force of oppression. However, it offered this chance that didn't previously exist for liberation. Okay, so women get equal protection under the law. This is going to be something you'll want to know about also in generally the 14th Amendment and its Equal Protection Clause being both equal application of the law and equal protection of the law. So we have this evolution of the 14th Amendment that actually coincides with the evolution of where we properly think power should be in our federal system. So early on, we look at the 14th Amendment, the Equal Protection Clause, as providing equal application of the law. And during that time, we felt states should hold more power than the federal government, or we were more statesy in terms of our power than federal government. As, however, we wanted the federal government to capture more and more power, our view of the Equal Protection Clause also changed from equal application of the law to what we now think of equal protection, which would be ensuring that everybody has equal rights extended to them. So women were able to fight for and get rights through the Equal Protection Clause, especially after it was interpreted as equal extension of rights to everybody. And the way the court did this was by creating a two-tiered system for judging cases before them. They have one tier which is called rational basis, and another tier which is called strict scrutiny. Okay, Now, all statutes, because when a court looks at a case, they're generally looking at a statute, right? Some sort of law the government passed and deciding if it's good or bad, constitutional or unconstitutional. A statute has what's called a statutory objective and a statutory classification. The statutory objective is the objective that the law is trying to achieve. So the Clean Air Act would have the statutory objective of making it so people can breathe the air outside. In order to achieve the statutory objective, the law has to target a certain population for regulation in order to achieve that objective. That's the statutory classification. It's the classification of people that the law targets. So the Clean Air Act has a statutory objective to clean up the air, make it so people can breathe, and it can go about doing that in a number of different ways. It can require power plants to put nitrogen oxide scrubbers on their power plants. So when basically they can require power plants, coal power plants, to prevent certain pollution from getting into the atmosphere. Or they could say everybody in America has a certain amount of power that they can use in a month. And by limiting the amount of power people can use, it will limit the amount of pollution in the air. The statute could say something that we would think of today as crazy, but maybe back in the day wouldn't be so crazy. Black people can't drive cars. Certainly things like that exist in other countries, either on gender or racial grounds, but for different reasons. But we need to protect the air, so let's say black people can't drive cars. The statutory classification, the relevant population, is the population or group of people or classification of an entity that is targeted by the law to achieve the objective. So, if the statutory objective is to make the air so we can breathe it, and the way it does that is by requiring power plants to pollute less, the statutory classification are the power plants. That's the relevant population. That's the population that's affected by the law. Okay? So the Supreme Court says, listen, there's oppression in America. We have historically had laws that oppress a certain group of people or different groups of people that violate our ideals of freedom and equality, things like that. So we need to start looking at laws when they come to us on a two-tiered basis. Again, that two-tiered basis is rational basis and strict scrutiny. In figuring out whether or not a law should be looked at through rational basis or strict scrutiny, the Supreme Court is first going to look at the statutory classification, the population of people that the statute targets. Okay? If the classification of people that the statute targets is what the court calls a suspect classification, then the law will be looked at by the Supreme Court through the lens of strict scrutiny. A suspect classification is a classification of people that has historically or is currently being discriminated against based upon some characteristic, generally immutable characteristic, and the court will define what those characteristics are and has. So gender, race, national origin, religion, all those would fall under strict scrutiny. So if a court looks at a law and they say, this law is targeted at a particular race, they would say, this law's statutory classification is target a race, and historically black people have been discriminate against. So this law's statutory classification is black people. Race, black people, white people, whatever, are a suspect classification. Since they're a suspect classification, we're going to apply strict scrutiny to this law. Once the Supreme Court looks at a law and says a law gets strict scrutiny, that means that the burden of proof is on the government for them to prove that the law is constitutional, that the law is something that absolutely is needed for the well-being of society. Now, you can think of maybe lots of hypothetical situations where discrimination is perhaps needed or desirable for the overall well-being of society. The Supreme Court, in creating these tiers, rational basis and strict scrutiny for looking at laws, and by creating suspect classifications, the Supreme Court isn't trying to say that there are some things that the legislature simply can never do. The Supreme Court is looking at these sort of laws on discrimination, saying, look, there could be hypothetically situations where there is a higher social good being performed through discrimination, that the consequence of not discriminating in some way is worse than the consequence of discriminating. However, if a state is going to discriminate, and if a state, in this case, in strict scrutiny, is going to discriminate against a group that has historically been oppressed or marginalized or discriminated against, the state must have a compelling reason, must have a sort of really good, overwhelmingly good reason as to why they need to discriminate, and the state has to prove that the objective they're trying to achieve is within the purview of the state. And the burden of proof in this case is all on the state. So you can think of a lot of laws that would be, and that have been struck down. Separate but equal, for example. The state justified separate but equal in saying that there was this, they had the authority to make it so that white kids and black kids went to different schools. That was within their legal purview. It was in their legislative ability. The states would then argue there's social good that comes from that it's somehow good for society that we keep white kids and black kids separate. The court, though, will look at that and say, well, listen, you're treating black people differently than white people, and that's a suspect classification. So you have to prove to us that, one, this is actually good for society that you're separating white and black kids, and two, that it's kind of overwhelmingly good for society, that there's some really, really bad consequence that will happen if you don't do this. Not that just there might be some sort of bad consequence. You can't, in our society, you can't abridge somebody's rights just because there's kind of a bad consequence that may happen to society because you abridge those rights. You have to have a sort of very big reason to abridge rights. And so the court would look at, separate but equal and say, the statutory objective is not one that the state can find. The state doesn't have the sort of legitimate rational interest to separate white and black kids. And there isn't any compelling reason why separating that leads to any social good. We're seeing a lot of the anti-gay marriage laws overturned and amendments overturned for the same reason. The fact is regardless of what you personally think about gay marriage, if you think it should be legal or not legal, the fact is that gay marriage does not lead to any negative consequences for society. It doesn't, or at least we have no evidence. And we have evidence actually to the contrary. So we have evidence that gay marriage does not break down traditional families. We have evidence that gay people can raise children and not make them gay, and raise them in situations where they're not being abused and stuff. These are some reasons that states have given for the reason why they need anti-gay marriage laws and amendments. But when the courts look at that, they're like, we need to see the evidence that this stuff is actually true, what you're telling us, state, that gay people being gay leads to pedophilia or whatever some people say. And the states are unable to produce that evidence, therefore laws are overturned. Though it's kind of a hopefully long-winded way to talk about equal protection and how that evolved, and you can see, I guess, hopefully how that applies to women, along with how it applies to every group. If there's a law that discriminates against women or disproportionately affects women, the Supreme Court can look at it and say, this falls under this higher standard of proof for the government, where the government has to prove that the law is justified, as opposed to the woman proving that the law is unjustified, or that burden of proof is. So Title VII of the Civil Rights Act. Civil Rights Act was passed in 1964. That banned discrimination on the basis of sex, meaning you could no longer not hire someone solely because of their sex. So I couldn't run a company and say, I am only going to hire men. Or, I guess conversely, I am only going to hire women. In most cases. Now it gets complicated when we're talking about things like bona fide occupational qualifications, but that's well beyond the scope of this course. Just know that maybe there are some exceptions, but don't worry yourself with them. But essentially, you can't discriminate anymore on hiring on the basis of someone's sex. Now, that adding of sex discrimination into Title VII almost did not happen. It only happened because a Virginia congressperson wanted to try and defeat the Civil Rights Amendment, or the Civil Rights Act, and thought that throwing sex into there, an anti-sex discrimination provision, thought that throwing that in the bill would cause it to be defeated, and he was wrong. And so we have that now. We'll move on to reproduction. So the footnote, or the cliff note version of this is that throughout time, abortion and contraception have been legal, widely available, widely used in all societies, religious traditions, social norms, etc. The only times there were restrictions on these things were either in an effort to control women's bodies, control women's place in societies, or to protect the property rights of men. So we would have cases where abortion was outlawed, or abortion may have not necessarily been outlawed, but the father of the aborted fetus could sue or press charges against the woman who aborted, or the person that helped her abort, if anybody did, for the destruction of his property, basically, or the violation of his property. This would generally be like a monetary damage. Was not considered a homicide. It was not considered killing a child, anything like that. In a number of religious traditions, Christian and Jewish, since a lot of people suggest that's the way we should look at sort of our religious foundation of laws in this country. Baby fetus thing was not considered a human life until after it took its first breath. So a woman would give birth, and a woman would give birth, and before that baby took a breath, it was not a human life. If the baby never took a breath, then it was never a human life. But once the baby took a breath, then it was sort of imbued with the rights and such of a human being, of a human life. So that's the kind of, in various degrees or another, the situations that existed for abortion and contraception until about the 1850s, 1860s, 1870s, where things slowly started to sort of turn against the right to use contraception and the right to an abortion. The American Medical Association started the push to get these things outlaws in the name of anti-obscenity. It was often or generally in the name of sort of controlling women, controlling women's bodies. There was also what we called a nativist strand to it, where the individuals that controlled these organizations were white Anglo-Saxon Protestants, WASPs, as we call them today. I don't know why the number 4 is associated. Ignore that. WASPs were scared about Catholics. Catholics had lots of babies, and there was this concern with immigration and with Catholic baby making that America would lose its Americanness and become a Catholic state, and we could not have that, of course. So, under that sort of justification also, contraception and abortion began to be outlawed, because we need to control women's bodies and we need to out-reproduce the Catholics, because we don't like people who don't share our religion in America. So those laws started to get passed in between, here and there, barely, starting in like the 1840s actually. But they actually didn't get started enforced in the courts and didn't get more and more sort of either extreme or start to have teeth to them, start to be enforceable until the very late 1800s, early 1900s. And some of the extreme versions of this is actually people, women or men, who even passed out information on contraception were arrested and jailed because they violated anti-obscenity laws against educating people about how to prevent pregnancy or sexually transmitted disease. There's 2 landmark cases we talked about: Griswold v. Connecticut and Roe v. Wade. People are very, I think, familiar with Roe v. Wade. It not necessarily directly, but kind of indirectly guaranteed women the right to have an abortion within certain guidelines. Griswold v. Connecticut is the legal case that made bans on contraceptive use between married people illegal. That struck down that law. So after Griswold v. Connecticut, hooray, if you're in Connecticut and you're married, you can use a condom. Before then, you were not allowed to use a condom according to law. You can read the stuff on Roe v. Wade. This Sandra Fluke testimony and Rush Limbaugh's response on there is really interesting in both how laws have been viewed around women's reproductive issues in terms of controlling women's bodies versus a woman's health issue. So Sandra Fluke talked about a lot of the health reasons that women need access to birth control. Health reasons including pregnancy, but the non-pregnancy health reasons. Of course, despite articulating those, and despite the fact that women have been articulating those reasons for a very long time, every argument against birth control comes down to it lets women become sluts, and we cannot have that. And that's part of that historical fabric. The historical way things have been viewed have moved its way into our culture today. Where am I at? Okay. So when we look at abortion and we look at contraception, we're looking at controlling of women's bodies. Another area that's been very dicey historically in terms of women's political rights, women's freedoms, and women's sort of emancipation from men has been around the issue of sexual violence and rape. So rape has been a way that men have exercised control over women for a very long time. Today, the primary reason men rape women is as an expression of control, not for sexual gratification, which is something a lot of people don't realize, don't know, or get confused on. It's about making somebody your subordinate. It's about expressing your dominance over somebody else. And rape, therefore, is used as a political tool to oppress women. It's been used historically, and that historical context, it still exists today, both in some of our laws that we talked about and in the way that we sort of view rape, the language we use about rape, the way we view victims of rape. As we talked about in class, for example, even today, if a woman is raped, inevitably, well, there's probably one example. So the vast majority of the time, somebody at some point asks a woman who was raped, well, were you wearing something? Well, like, what were you doing at the time that, brought on this rape? What did you say? Did you kiss him? Did you have anything to drink beforehand? Did you you left the party by yourself? Really? Implying that for any of those actions, or for any of those reasons, the woman is partially blamed for the rape. That's not a logic that we apply to a lot of other criminal cases. It would be strange to go up to a murder victim's family and say, really? He was wearing that? I mean, well, I guess he's partially to blame. He had a drink of alcohol and then he got murdered? I mean, it's sad and he shouldn't have been murdered, but I mean, he's partially to blame, right? It's that kind of logic, that kind of thinking. The kind of idea that somehow women's bodies are, at least in some minor way, the property of men. Not 100% the property of men like they used to be, but there's still some amount of ownership that men get to claim over women's bodies, and that is expressed a lot through our rape laws and sexual violence laws, the way rape and sexual violence cases are treated in the criminal justice system and in the courts, and the way we as a society and culture view such instances and such crimes. So as an example, we talked about how in 2013 the Norfolk Virginia Police Department had to rewrite their policies that went from treating a woman who reported a rape as a criminal herself, interrogating her like a criminal, to treating her like a victim, like you would treat anybody else that came in and reported a crime. So if I go into a police office and say that somebody broke into my house, they're not going to immediately start, trying to poke holes in my story, trying to say that I'm lying, and somehow they're going to be like, okay, well, I'm really sorry this happened to you. Tell us what happened, where were you, what was stolen, what was taken. After that, they'll probably come by the house then and see if anything was stolen. But they're not going to immediately, once I walk in the door, if that's the way I report it, treat me as a criminal. But that's the way they were treating rape victims. We talked about in 2010, in the North Carolina Supreme Court ruled that if you initially consent to sex with somebody, you cannot withdraw that consent. So let's flip it around, because men get raped also. A man and a woman say, hey, let's have sex. That's going to be so much fun. So they consent to having sex. About 3 minutes into it, the man decides he's not having fun anymore. He gets, he just doesn't want to do it. It's okay, right? You're allowed to not have sex if you don't want to. The man says, you know what? I don't want to have sex anymore. Can you please stop? If the woman's like, no, I'm going to keep having sex with you. You've consented to this. You said that we could have it. You've got me all worked up now. We've got to keep going. The Supreme Court of North Carolina said that that is not rape. That the man in that case would be, I guess, obligated to continue with the sex, even though he didn't want to have sex anymore. That while at least I would, and I think a number of people in the class thought doing that would be considered rape, even if it would be difficult to prove. If you keep having sex with somebody against their will, then that becomes rape. The North Carolina legally in 2010 said actually that was not rape, that it was impossible to rape somebody once they consented to sex, even if they withdrew that consent. So I guess legally they couldn't even withdraw that consent halfway through or at any point during. And why do we have ridiculous laws like that? And that's kind of the question that I'm trying to get at. The issue I'm getting at with this entire section is, why do ridiculous laws like that exist? Why does anybody consider it okay to continue to have sex with somebody after the person has said, I do not want to have sex with you anymore? And that's because of this historical tradition that has worked its way into the political and legal framework of our society, into the cultural framework of our society, that has yet to be sort of gotten rid of. And that's also actually part of the reason why we need things like women's political sections, because there's discrepancies in the way people are treated, as I said earlier. So that's in there. Look at the statistics on rape. These are best case scenarios, and however you want to look at it. So best case, 60% of rapes are reported. We would like it to be 50% or 100% of rapes to be reported, but at best case, 60% of them are reported. Sorry. Best case, 60% are not reported, which means only 40% are reported best case. It could be as low as 25% are reported, or as high as 75% of rapes are not reported. At most 10%, so it could be 9%, 8%, but it's not 11%. At most, 10% of rapes lead to an arrest. And one thing I didn't mention, if you're looking at that slide 34, it's important to notice the change from rapes to rapists. So a lot of rapists commit, well, some rapists are multiple rapists. 8% of rapists get prosecuted, which is different than saying 8% of rapes lead to a prosecution, if that distinction makes sense to you. Now, false reports, which is becoming a huge deal now as we've had more of a push towards making it so women feel safe to come forward with reports of rape, while we've been trying to change the social and legal framework so that women have safe spaces to report rape, and to try and, get some legal redress for the harm that was done to them. The pushback that we've been getting sort of overwhelmingly was, well, women will falsely report rape, and they'll falsely report rape a lot. And oftentimes, they may report a rape just to get back at a guy. They'll have sex with some guy, and then they'll say she was raped, and then they'll go, ha ha ha, got you, guy. And, how can us guys be protected from women that would falsely report a rape? Okay. We find statistically that's not a lot of the reports that happen. 2% of reported rapes are proven to be false allegations. Up to 8% may be false allegations. But it's not, I think, the same sort of institutional sexist oppression that a lot of men are trying to say it is, who are pushing back against women's ability to try and get redress for being raped. And the final part of the section, the point I want to make is representation matters. We have a segregated society, both racial, sex segregated society, a socioeconomic segregated society. If you have people that hold power in society, whether they be the business, hold power in business, hold power in government, that are from the same segment. As today we have overwhelmingly the people that hold power both in business and in politics are straight, white, upper class, very well off men. They don't have the same life experiences as other people do. They don't fully understand what it's like to be a woman in society. They don't fully understand, what it means to be a woman in a sexist society. They don't understand what it means to be black in a racist society. They don't understand what it means to be poor in a capitalist society. And so if representation isn't divided amongst all those groups of people, you'll get laws that just perpetuate, even subconsciously perpetuate, a lot of the sexist and racial sort of institutions that exist in society. You can already see a lot of the changes that have happened just from women gaining a little bit of power. And I think more changes will come as more and more women are able to access political power. But there it is. Hope you enjoyed that review. Hope it made sense. Have a good day.